Welcome everybody to today's Employment Law Boardroom based around redundancies. The call is being recorded. Most of you know me from previous boardrooms, but for those that don't, I'm Amy McLeod. I'm the recruiter for the South East region of HR Recruit. I'd also like to welcome to the call Sarah Whitemore and Natasha Young from Warner Goodman, who are helping to facilitate today's call. And thank you to Karen also from their marketing team, who will be helping out with today's presentation. I'm going to pass over to Karen shortly and she'll start with the slides.
Thanks, Amy. So I'm really pleased to be invited back to speak again today. We obviously had one of your boardroom sessions earlier in January, which was really engaging and we really found it quite informative ourselves, as well as hoping to share information with your delegates. So it's good to see so many familiar faces. I think there's about 90 people on the call or something like that. So obviously can't see everybody, but nice to see so many of you that came to the last one, and to welcome the new attendees as well. So my name's Sarah Whitemore, and I head up the what we call the Peace of Mind team at Warner Goodman, which is a team that support employers through retained packages. And I'm an employment lawyer, and I've been with the firm for about 30 years, just dealing with employment law issues. And I'm joined today in terms of presenting by Natasha Young. And Natasha is an HR manager herself, employed by the firm to support our clients. So she's externally facing and deals with redundancy processes, amongst many other things, but I'm sure she'll give you her introduction as well when she joins the call. So it's interesting that we've been asked to talk about redundancies this week, because personally I'm feeling as though it's quite positive this week. Obviously, we've just had the roadmap given to us in terms of how we're going to be reopening and looking to bring more and more people back into the workplaces as we head towards June. And the CIPD, I'm sure you will all have seen, released stats this week showing that 56% of employers are looking to recruit this quarter. So it sounds fairly positive in terms of the world of work. So it almost feels a little bit strange to be talking about redundancies. But we had an event ourselves earlier this week, and we did a poll at our event, and 40% of the people on the call indicated that they were currently contemplating redundancies. So that's quite a high percentage. And I think as we move towards the end of furlough in particular, which at the moment you'll know is scheduled for the end of April, people will need to make decisions about whether they bring people back to work from furlough, or whether they look at reducing headcount. And of course, if you've had somebody on furlough for the whole of the last year, you may well be thinking that that's not something where you're wanting to bring somebody back into the workplace. So the presentation that we have today is going to give you an overview of redundancy. For those who haven't done a redundancy process before, we're going to just look briefly at the redundancy process that you will need to follow. But then in the second half of our event, we're going to have a discussion piece. Natasha and I are going to be talking about some of the tricky issues that we're asked about in terms of redundancies. And we'll also have the opportunity for you to ask questions or to join in at that stage as well, if you want to. There is a chat facility on this Zoom call. I'm sure you've all found that previously. It's either at the top or the bottom of your screen. And if you have got questions along the way, do feel free to enter them into the chat box. I personally find it difficult to see those whilst I'm presenting, but there will be an option at the end for us to go through and review those. And I'll be asking Amy what's come up in that and hasn't already been addressed. So do please put your questions in there if you have any. So many employers are already taking the view that if they've managed without furloughed staff, for the past year or even just since Christmas or whenever. And if they've got no prospect of their order books filling to occupy those staff in order to bring them back to work, that they need to reshape their business and make sure that the model they have in terms of their people structure suits the business, suits the work that they have coming in. And we're often asked whether that's an option, whether you can consider redundancy when employees are on furlough leave. We're often asked whether you can dismiss somebody or whether you have to hold back your redundancy programme until the furlough option disappears. The starting point for any redundancy process, and this would be the case pre-COVID as well, is for you as a business to consider ways to avoid redundancy. So traditionally that would mean looking at things like a wage freeze, an overtime ban, a recruitment freeze, looking at things like removal of temporary or agency staff, possibly looking at wages cuts, hours cuts, and calling for volunteers. And considering the use of furlough leave as a way of avoiding redundancy is one of those factors. So you should be considering that before you launch a redundancy programme. But it's not a prohibitor to redundancy. So the fact that you have people on furlough does not stop you dismissing them or implementing a redundancy programme. It's just another factor to consider before you start redundancies. There may be many reasons why you would choose not to continue to use a furlough scheme. If you've decided what your model is going to be for the future, you may well want to have the staff who are going to be running that model and performing in that way to start working to that model sooner rather than later. So you might want to restructure your business before you look at something further down the line when furlough has finished. People can then be engaged in their new roles, they can be focused in their new roles, and they can be delivering to your new targets and goals. But also, you need to keep in mind that it's not an entitlement. Nobody has an entitlement to be on furlough leave. It's your choice and not theirs. And there are risks for you in continuing to have employees on furlough leave. Obviously, there are certain costs. So you pay employers national insurance and pension contributions, and holiday will continue to accrue whilst they're on furlough. So they're costs to the business. But you also run the risk that they may acquire an additional protection, such as becoming pregnant, acquiring a disability, that mean that when you come to the process later on, it makes it harder for you to dismiss that individual. So there are lots of reasons why you wouldn't keep people on furlough and why you would opt to proceed with a redundancy. And all that we would say is that at the start of the process, you should make a note to show that you have considered using furlough as a way of avoiding redundancy and to show why you have discounted it. So the basics to start with, redundancy is one of the potentially fair reasons for dismissal, as you will know. So if an employee has more than 2 years service, you need to have a fair reason to dismiss and you need to follow a fair procedure, and redundancy falls into that category. And with those who have special case protections, so if you have whistleblowers, you have people who are pregnant, you have people who've raised health and safety matters, people who are trade union activists, you should follow a fair procedure for those. And again, with those who have protected characteristics, to avoid the risk of discrimination, you should follow a fair procedure with those as well. And if you have more than 20 employees that are affected, then of course you'll need to start with a collective consultation process. We're increasingly seeing collective consultation. It's something that we didn't deal with a lot in the first sort of 20 years of my practice, but we do seem to be doing it a lot more now. And as I say, this is where you've got more than 20 employees who are affected, or more than 20 who are going to be dismissed by reason of redundancy within a 90-day period. So you might have waves of redundancy, and you need to look on each occasion, not only at the number of employees that are being affected in that wave, but also how many you've previously made in the last 90 days. If there are significant numbers of people affected, then the obligation that you have is to consult and to do so with an appropriate representative. So your appropriate representative would be your recognised trade union if you have one, and that's an official appointed trade union that's recognised by your business. Or it could be employees who are already elected for that purpose. So you might have a standing body like a staff consultation committee, and provided it has as part of its terms of reference collective consultation, then you could consult with them. But if not, then you would have to elect people specifically for the purpose. And so you need to factor that into your timeline, that not only will you have your 30-day or 45-day consultation, depending on numbers, but you will also need to spend a few weeks sorting out an election process. Now, the election process is in your hands. You can choose how you elect You can choose how many people you're looking to elect, what constituencies they're going to represent. So you might say, well, we want 5 or so people to consult with. We want 1 from the shop floor. We want 1 from the office, 1 from the canteen, or whatever it might be. And those decisions are yours, and you can choose how to do the election. And we found during lockdown and in the last year that the best way to look at these elections is by doing it over email. So you effectively give them a single point of contact, which they can send in their nomination forms, send in their election forms, and things of that sort. There is a defence to failing to collectively consult, the special circumstances defence, which is on the slide there. And it's something that we were looking at in the early stages of the pandemic. It's something that was used back in the 1970s. And it's to do with the fact that you have to make an immediate change and you don't have the option to go through a collective process. And it's about dealing with a sudden disaster. So if a sudden disaster strikes a company, making it necessary to close, then you can avoid the collective consultation process. And at the start of the pandemic, a lot of employment lawyers were saying this could be that sudden disaster. We weren't expecting COVID. We didn't know what the impact was going to be. We'd no idea of downs. This is that sort of situation where we could avoid collective consultation. But now is that we're all used to how we're living, how we're operating, how we're functioning through lockdown, and have been for quite considerable time now. And we don't think that the tribunals will readily accept anymore that the special circumstances defence can be used in this situation. What happens if you don't consult? Well, if you fail to collectively consult, then your staff can claim, in addition to their redundancy payments and so on, a protective award, which is up to 90 days pay. So it's calculated at full pay rates, not capped in any way. So it's quite a significant amount of money if you fail to consult. There were some question marks earlier on about whether we could go through collective consultation whilst people were furloughed and how we would do that practically. And the government guidance was clarified to say that people who are on furlough can still be involved in consultation. They can be employee reps whilst they're on furlough leave, and those activities are not considered to be working, and so they can remain on furlough leave throughout. In terms of the practicalities, we've put a question mark there around consultation by Zoom, and I think Tash will say that, you know, at the start we had a lot of conversations with people about whether you could have any form of discussions with employees over Zoom, you know, whether you could deal with dismissals by reason of misconduct or capability, those sorts of things, and how people would react. But those questions have long since fallen away. We really are quite happy to have these sorts of meetings by Zoom, and consultation meetings are no different. You can have those over some form of technology such as this. So remember, it's all subject to existing employment law, and there is a need to follow a fair process. You need to consult with your staff, and if they've been with you for more than 2 years, you need to do that on an individual basis and to select them fairly. And we would say, don't just knee-jerk into selecting those who have been on furlough leave. They may be the obvious candidates, but it may also be the case that there are reasons why they've been furloughed, which mean that it's better for you to choose somebody who hasn't been furloughed. Perhaps they've been furloughed because they were shielding or something of that sort. So moving on then to looking at the process for individuals. So in all cases, collective or otherwise, there is a requirement for individual consultation. With a collective consultation process, you would do the individual consultation at the end of collective consultation or towards the end of it. But with all others, you obviously would start with an individual consultation process. And what we're looking for here is to convince an employment tribunal in due course that what we've done is fair and reasonable. So that means before we take any decisions about individuals, they have to understand that they are at risk of redundancy. So we start by placing them at risk of redundancy and confirming that in writing. They need to understand why they are at risk. So you would have a conversation with them about your proposals and your rationale for your proposals. They need to have the opportunity to put forward ideas themselves, to put forward ideas about the selection process, ideas of ways to avoid redundancy. and also ideas about who should be selected rather than them if they think it's not appropriate for them. And that will usually take place over a couple of meetings. People often ask us, how many meetings do I have to have? Well, you would normally have an at-risk meeting, which the employee wasn't expecting, at which you simply tell them that they're at risk and what your rationale is. And then you would normally have a couple of consultation meetings so that you can be seen to be reflecting on the comments that they've raised. If you need to go through selection from a group of employees, let's say you're reducing down from 5 to 3 in a particular group, then you're likely to need to have a further meeting. So you're likely to have a conversation with them all about what your criteria are going to be, so you consult about that. But then you're also likely to have a meeting about why they've been scored, the way that they've been scored, or how they've been scored. So that if you've given them a certain score for attendance, for example, they have the opportunity to challenge that before a decision is taken. Also, at this stage, you again want to think about the practicalities. So you need to think about your communication channels, and as we talked about before, whether you do something over Zoom. You need to think about whether you're going to record the call or whether you're going to have an extra person on the call as a note taker. And generally speaking, we're finding that you need to take a bit more time over a call that's done or a meeting that's done over Zoom, particularly in the case of people who are not so familiar or comfortable with the technology and need to take more time to consider what their responses might be or how they might feedback. So that's just a high level overview of redundancies. But as I said at the start, there are some sort of tricky areas and questions that we're often asked. And so Tash and I are going to run through some of those now. But as I mentioned right at the beginning, we're more than happy for you also to raise any questions or queries that you have about your own processes. And feel free to put comments in the chat box and we'll pick those up as and when we can.
Hi everyone, I'm Tash. As Sarah said, I work with Sarah as an HR consultant, so mainly for our clients. And one of the key areas that I tend to get involved in are business restructures, and so redundancies as part of that. One thing that comes up a lot when I'm working with clients is who to pull for redundancy. In my experience, clients often feel that the pool is everyone with the same job title. But this isn't always the case. Sometimes you do need to go more broadly than that. Is that something that those of you that are here today have had issues with? Has anyone had any particular issues with regard to pooling? I think what I've tended to find is that people think, well, you know, they're a different job title, so we can leave them out of it. That's often the area that you get the challenge with, because sometimes actually that person is doing a very similar role. So it's important to look at what's actually happening in the role as well as looking at the job title. Sarah, you said in your presentation that people should be wary of selecting the group of people who'd previously been on furlough. But what other tips would you give on this?
So as you know, Tash, the first stage really in any redundancy process, once you've got over the hurdle of deciding that there's going to be a redundancy, is to determine what your pool is and who you're going to be choosing from and which group of people you're going to be placing at risk. The employment tribunals are fairly relaxed about this, provided the employer has applied some sort of logic to the definition of their pool. The tribunal are really more concerned with, have you got the right people in the pool based on your definition, than what your choice of pool is in the first place. Sometimes it will be obvious. So if you're closing an office or a factory, then clearly everyone who works in that building is going to be at risk. So that would be your pool. Or it might be that you're removing a particular type of role. So we're no longer going to have secretaries. So all the secretaries from a particular office or something of that sort might be at risk. But usually the pool is defined in some way linked to the job title and possibly also to geography. So you might say, for example, we're going to have a pool of plumbers in Aberystwyth. And what you would then do is, if you had a plumber who works in Cardiff, you wouldn't need to include them in the pool. Or if you had a gas fitter who works in Aberystwyth, you wouldn't need to include them in the pool. So it's some way of actually identifying the role that you no longer need. How wide or how narrowly you draw your pool is a matter for you and not for the employment tribunal. Each employer will view this slightly differently and will structure their business in a different way. And what the tribunal will say is that they look at the range of reasonable responses, just as they do with misconduct cases or capability cases. They will recognise that there are a range of reactions of employers to situations, and that not every employer is going to define their pool in precisely the same way. But provided your definition fits within what's considered to be reasonable, then they will be supportive of it. What they will want to do, though, is to make sure that you've included in your pool the people who have the same or similar duties. So the fact that people have different job titles does not necessarily mean that you can exclude them from the pool. If they're doing the same or similar work, but they happen to have been given a different job title, then you should include them. So you're looking for interchangeable skills. So, for example, if you have a brand manager on a particular product and you have a brand manager with a different product, and the only difference between them is the product that they're using, but they're using the same skills and so on, then you might put them both in the same pool. Or for a different example, you might have, we had a client just recently, and they had printer operators and printer operators / drivers. So these printer operators all worked within the same warehouse, but one group of them used to go out and also do deliveries. And they decided that they wanted multi-skilled people for the future of their business. And so they decided to draw their pool as just including the printer operators and not the printer operator / drivers. But you need to be very clear that the people that are in the pool are in interchangeable roles, and your reason for how you draw your definitions. One of the things that you need to make sure is that you do have a clear rationale for your pool. And with all these things, it's worth documenting it, because the tribunal love making decisions based on bits of paper. So at the start of your process, you might make a little note to explain what your pool is going to be and how you're going to justify or rationalise it. And within your consultation, you can then invite feedback on it. So you can explain to the group what it is, what's the pool, how you've defined it, why you've done it in that way. And then if there's a challenge from them, you can either amend it if it's a legitimate challenge of something that you hadn't thought about, or you can come back with a reasoned response, and that hopefully closes the situation down. But again, note it during your consultation.
And another one in the opposite direction, I suppose, Sarah, is where there only seems to be one person in the pool. In my experience, clients often feel that they're being unfair somehow by just picking one person to pool, and worry that that might be challenged. So can they have a pool that's only got one person in it? Yes,
very much so. We have a pool of one situation. We would describe it as a singleton redundancy or a singleton pool. I mean, it's quite common. And it might arise where you only have one person who does a particular role that you're losing. So, for example, we've been working with a client who's just recently changed their stores operation. So they used to operate on the basis of having a stores assistant who went to the stores and collected the items that were needed and dealt with goods out and so on. And they've changed to what they describe as an open stores situation, where anybody in the warehouse can go and pick stores and so on. So they don't need a stores assistant, and they only had one stores assistant. So that stores assistant is the pool. That's the person that they're consulting with, and that's the only person they're consulting with. The risk when you only have one person in the pool is that they may say that you're targeting them, you're picking on them in some way. And if they've got a special protection, so if they've been a whistleblower, or if they happen to have just told you that they're pregnant, or they've got protected characteristics, then you do need to be very careful that you can demonstrate exactly why you're choosing to make that role redundant. But in the example I gave you, there's just no longer a need for a stores assistant. So that's their rationale for having a singleton pool.
Okay, so I have my pool, but the next issue tends to be how I select. We have a few options here, don't we?
We do. So most employers tend to draw up a list of criteria that they assess employees against, and then list employees in order of their scores. So they draw up a matrix where they have all the scores, all the categories, all the employees scored, and that generates a list of employees in the order that they want. I think quite often employees employers start with the list in the order that they want, and then they work out the criteria that's needed to get that list in that order, but we'll park that for a moment. The tribunal, again, don't mind what your criteria are. They're not going to say, well, you should choose on the basis of skills, or you should choose on the basis of productivity. It's up to you. You choose your criteria, and your criteria will usually be linked with what you need for the business going forward. But they tend to prefer you to choose objective criteria, so things that you can specifically measure. So things like skills and productivity, qualifications is a good one. Things that you can verify are often good choices for selection. It's relatively rare for an employment tribunal to find a dismissal unfair based on the criteria that you've used. It's more common for them to find that it's unfair based on how you assessed people against that criteria. So you need to be able to support your assessment. So if you have two managers, for example, doing the assessment, having them make notes as to why they've chosen a particular score for a particular person on a particular criteria is great. If you've got paperwork that backs that up, and if it links into their appraisal and you're able to demonstrate comments that were made in their performance review, great. It's also helpful to have a scoring guide. So quite often employers will say, well, we're going to have disciplinary record, for example, as our criteria. And then they will say to the managers, if somebody has a clean record, score them as a 5. If they've got one written warning, score them as a 4. If they've got a final written warning, it's a 3, or something of that sort. So the managers have got a clear understanding of where their points will come for individuals on their criteria. Obviously, you should avoid criteria that might be considered discriminatory. So the old last in, first out tends to be frowned on now because it can be considered to be discriminatory on the grounds of age, although you can use it if you need to, if you can justify using it. But things that adversely impact on, say, disability or maternity, things where you score people on absences or sometimes on skills, if it's affected by their disability, they should be avoided. Or you should consider how you would adjust their scores to reflect that risk. And many of you will be aware of the maternity leave case involving a firm of solicitors, Eversheds. They were scoring people based on an appraisal, and one of their ladies was on maternity leave and hadn't had an appraisal at the relevant point. And so they just decided that they wouldn't treat her harshly. What they would do is adjust the scores and give her a full score because she hadn't had the opportunity to be assessed. And that sounded great until one of the men said, well, that's actually not very fair to me because I've been scored on my appraisal. If I'd been on maternity leave, which incidentally it couldn't happen, but if I had, maybe I would have got full score too. And he was successful in his argument, and he was able to say that he had been discriminated against because they hadn't inflated his scores. So the tribunal in that case said, well, really what you should have done is go back to the last appraisal that everybody had, the last level playing field, look at what the assessment would have been at that stage, and base your scores on that. So there are some complexities around it, but largely the criteria you choose and how you assess is down to you.
Yeah, so the next question that often comes up is after the person's been selected, you tell them, you follow up with the letter. Now, if I'm dismissing someone for misconduct or capability or even SOSR, I'd usually offer them the right to appeal against my decision. Can we have a quick poll? How many of you offer the right to appeal in a redundancy situation? You can just click on one of the boxes. Okay, I think the results, Amy, can you see the results for us there? Yeah, so I'm not surprised by that, but you know, it's obviously it's not all of you. So 73% are saying that they do offer the right to appeal in a redundancy situation.
Yes, it's really interesting, Tash, because nobody really knows the answer on this one as to whether people are entitled to appeal against a redundancy decision or not. there's no legal obligation to offer an appeal. There might be an advantage to doing it, and we'll look at that in a second, but there's no legal obligation to. So the ACAS Code of Practice, which is where the idea of having appeals comes from, only applies to disciplinary and grievance procedures. It's not applicable to redundancy situations. So there's no requirement to have an appeal. Your staff handbook might have a redundancy policy in it. And if it does, you should check within that whether it says that there's a right to appeal. There's a very old redundancy case of Robinson and Ulster Carpet Mills, which says that there doesn't need to be an appeal. And in that case, there were 3 employees who were dismissed on grounds of redundancy, and they weren't offered a right to appeal. They brought a claim for unfair dismissal, and the Employment Tribunal and then the Employment Appeal Tribunal in Northern Ireland determined that an appeal procedure was not required. Now, it's a 30-year-old case, so it's not necessarily current law. It's 30 years old, and also it's a decision from Northern Ireland rather than from our own courts here in England and Wales. But it has been approved in a UK court case, the court case of Gwynedd Council and Shelley Barrett, where it was also said you don't need to have an appeal. And we find that in redundancy situations, appeals can cause confusion. Because basically, if you allow somebody to appeal against a redundancy, you need to put on hold everybody else's decisions. Because if you've selected one person to be made redundant and 4 people who are not, then the one person who appeals, if they're successful in their appeal, it inevitably means that one of the 4 people who were not going to be made redundant will now need to be made redundant. So you would have to go back and unpick those decisions. So effectively, what you would have to do is to say, that one person has been chosen to be made redundant. You 4 people, we've reached the end of consultation, but we're not declaring the outcome until we know what happens on the appeal. So that can cause confusion. And of course, it also causes unsettlement in the workforce, because you want to reach the end of the process. The ones that you're retaining in your business, you want them to be focused and re-energized, having gone through this fairly traumatic experience. You may choose to have an appeal, though. There are some situations where we would strongly recommend an appeal. And that would be particularly where you think there's been a flaw in the process at some point, where you are doubtful about what the managers have done, or whether you want to revisit an outcome that you don't think was particularly fair. So it's an opportunity to correct past errors. But personally, I would say take it from the approach that there doesn't need to be an appeal unless you feel that you're at risk.
Thanks. Another area of confusion, I think, particularly with people who've made redundancies earlier and then redefining their workforce now, is whether they can recover any money from the CIRS grant in relation to payments made in a redundancy dismissal.
Yes, particularly back in the summer, there was quite a lot of confusion around CJRS grants and what you could and couldn't claim. And some of that was clarified in December. So if you dismiss an employee who is on furlough leave, you can either dismiss them with immediate effect and pay money in lieu of notice, or you can dismiss them with a period of notice, so their employment comes to an end after a period of time. They can still stay on furlough during that time. In the latter case, where they were serving notice but on furlough, for a while, you could still claim your CJRS grant against your notice pay. But since 1st of December, that's no longer the case. So when somebody is on notice or they receive pay in lieu of notice, you cannot claim that against the CJRS grant. Similarly, with holiday, when you dismiss somebody, you can either pay them their accrued holiday as a lump sum, in which case you can't claim that against the CJRS grant, or you can require them to take their holiday, which you might require them to do during their notice period, particularly if you've got a clause in your contract of employment that allows you to do that. And whilst you won't be able to claim that against the CJRS grant, because then now in their notice period, it does mean that you avoid double payment. So you're not paying them for their notice and for their holiday. You would just be paying for the holiday as part of their notice period. The statutory and contractual redundancy payments have never been recoverable on CJRS grant. So the majority of payments that you make are not going to now be recoverable through the grant money.
Thanks, Sarah. Here's one that we get asked a lot, and more recently has come back as a criticism from unions. If I can just have I don't know if we've got a poll for this one, Amy, so it might be a quick show of hands. How many of you have a redundancy policy within your business? Okay, just waiting for that to come through. So actually, it looks as though most of you do. We've got 76% there saying they have got a specific redundancy policy. So the question is, I suppose, is that necessary? Do we have to have a redundancy policy?
Yeah, I'm quite interested by that. So that's about 3/4 of the people have got a redundancy policy. It's not something that's compulsory. And when we do a lot of work with employers, preparing staff handbooks, providing policies, writing policies and so on, and we don't routinely provide redundancy policies. There are advantages to having them. So it gives you a guideline for your managers to follow. So if your managers don't routinely do redundancy work, then at least they've got the outline of what the procedure is. They've got perhaps the criteria that you tend to apply. They might have details of your enhanced redundancy pay if you pay more. But there are also disadvantages. And the disadvantages really are that if you fail to then follow your procedures, you're going to be criticised for that by the Employment Tribunal. So you're going to then have to come forward with a very clear explanation as why you didn't follow the procedure that you had publicly declared as being a fair procedure to follow at a later stage. And so, you know, if you want to tie your hands and make sure that you do follow, that's fine. If you want to give yourself flexibility to have a different redundancy process to suit whichever circumstance you've got, then you probably wouldn't have a policy in your handbook. So Tash, I think there've been quite a few questions. I've seen them popping up in the chat as we've been going through. I don't know if it's worth at this stage perhaps picking up on some of those and we can have a look at answering those.
There are, and I think some of those are questions that a lot of people will be wondering about actually. Nicola was asking about if the manager's holding a consultation meeting, should they be the note taker as well, or is it better to have another person? In this particular case, she's saying the minutes aren't recorded. So
yeah, I mean, from an employment lawyer's point of view, it doesn't really matter what you do, so long as you've got a note of the meeting at the end of it. I'm sure, though, in practical terms, from an HR point of view, Tash, you'd probably agree that it's much easier if there's somebody separately doing the note taking, because then the manager can focus on the actual discussion, can be seen to be listening to the employee and taking feedback and responding to it. And meantime, somebody else is preparing the notes. And also, from an employment tribunal point of view, you have two people that were in the meeting on behalf of the employer. And so if for whatever reason you are taken to tribunal, and if for whatever reason one of the people in the meeting is no longer with you, you've got a second person who can be a witness as to what occurred. And if somebody's saying, oh, the manager was overly aggressive or kept shouting at me, well, your note taker's there to say it didn't happen like that. So I don't know what your experience would be, Tash, on that.
Yeah, absolutely. I would always have some other person there if possible, and you know, if I'm doing that as an external person, I'll either say to them, would you like somebody, you know, and they'll often have a secretary who would do notes for us, or if I'm doing the meeting by Zoom, I'd usually say to them, can I record it? And people don't generally mind that because they know that they're going to get a full transcript afterwards, which will be, you know, an accurate record of what's been said. So I think it gives them some comfort as well as me, you know, that I'm, as you say, if there is a challenge, I can go back on it. The next one was Michelle was asking about different technologies being used in a given meeting. So we've just mentioned doing Zoom meetings there, for example. But Michelle was asking, can some be voice only and some be, I think you mean video and voice, Michelle, is that right?
Yes, so
yes, sorry, that is what I was asking. Just where they're normally because if the board bandwidth goes and a person can only attend by voice only, by moving onto a mobile phone, for instance. The practicalities of that and the best practice around that.
Yeah. So as I said right at the very beginning, what our job is in the tribunal is to convince the tribunal that what you did was fair and reasonable. So in an ideal world, you'd sit down in a meeting room in your premises, face to face, and you'd have a conversation in that way. But we haven't been in an ideal world for the last year. And so, we've gradually had to look at different types of technology. So second best, I would say, is some sort of video link based conversation, because you can still see people's faces, body language, etc. Although obviously you can't see what they're doing with their hands, or the fact that I've got my slippers on at the moment, or whatever it might be. If you haven't got that technology, if you haven't got the ability, or your staff member lives in deepest Wales and they've got no broadband or whatever, then a phone call is going to be the next best thing from that. So it's about being able to show to the tribunal that you did the best you could and your reasoning why, and we tried to do it this way because of whatever, it didn't work. Now we've tried to do it this way.
Yeah, and I think, as Sarah says, it's really about sort of having that conversation with the person. So, many times, because I've been working from home and been consulting with people, or even having grievance or disciplinary meetings in that way over Zoom, and it doesn't always work. If someone's coming in and they're saying, Tash, I can't, I can only get the voice, I can't get the video to work, I'll usually just say to them, look, do you want to reschedule? Because I know it feels better and it feels more like a normal meeting when we can both see each other. So, I'm happy to try this another time. But most of the time people say, no, I'm quite happy to do it now because we had it scheduled, and they're kind of ready for the meeting at that point, and they would rather go ahead with just voice. So, I tend to give them the option, but, most people are quite happy to go in that way. And
I think actually, sorry. I was just going to say about the situation where you had a meeting over Zoom, and then somebody's parent or something was chipping in. You didn't even know that they were in the meeting, and so you're now sort of starting the Zoom calls by saying, can I just establish who else is with you? And because you don't really know what else is going on in the environment.
Yeah, absolutely. It's kind of become part of the housekeeping list at the beginning. I've had a couple of meetings where people have been in their car, bizarrely, where they're having the meeting on their phone, and I will say to them, you've obviously got the right to be accompanied. It looks as though you're on your own. Are you on your own? And then they'll sort of zoom around and they'll be like, no, my wife's here. So it's just one that I check. It's worth checking, just so you understand who's with them.
And the right to be accompanied is quite interesting, because on redundancies, there is no right to be accompanied until the last meeting, because the entitlement is to have a companion with you if you're likely to be dismissed. And obviously that would be a workplace colleague or trade union rep or whatever. There's no entitlement to have somebody with you at the at-risk meeting. There's no entitlement to have somebody with you at consultation meetings. Most employers do allow it, and it's very difficult to see a situation where you would want to deny it necessarily, but it's not there as an entitlement. Okay,
so we've got a question from Anthony Harris, who's saying, we have employees that are customer facing, and it's envisaged that we're going to be consolidating geographical working areas, thus reducing our headcount. On the back of the decision by Pimlico Plumbers not to offer work to anyone who has not or cannot prove that they've been vaccinated, can I use this as part of the selection process? If not, having considered reasonable measures, and if we are not offering work, what would be the fair reason to bring employment to an end? Anthony was thinking SOSR, as the contract is frustrated.
Okay, so the whole topic of whether we can require people to be vaccinated or not could be a seminar in its own right. We did deal with it at the last boardroom, actually, as it happens, but in the context of redundancy, you could have it as one of your criteria for how you're choosing people. Now, obviously, at the moment, we're only looking at about a third of the population having been vaccinated. So you're going to find a vast majority of your current workforce haven't been vaccinated. But as we progress along, more and more people will take up the opportunity. To choose somebody because of their vaccination could be discriminatory. So you need to be mindful of people who are pregnant, who can't necessarily have the vaccine. I think at the moment the recommendation is that they don't. You need to be mindful of people who have a disability. They may be needle phobic of some sort, or they may have some sort of disability where their medication doesn't work well with the vaccine, or vice versa. You need to be mindful of people who have religious beliefs or philosophical, I can't ever say that word, philosophical beliefs that are the equivalent of religious belief, that philosophical beliefs, the anti-vaxxers. Now, they may or may not be sufficiently strongly opinionated, strongly believing to be protected. We'd need to look at that carefully. But the point is, there are categories of people who you would be discriminating against if you didn't make allowances for them as part of your selection criteria. So my advice, Anthony, would be include it as one of your criteria. If somebody explains that they won't have a vaccine, discuss with them why they won't have a vaccine. When you get to the bottom of what their reasoning is, then take some advice about that particular person's situation, see if that does amount to discrimination or not, and then revisit your process. If you've got somebody who's just, I don't want to be vaccinated because they're putting a chip in me and they're going to be tracking me, or because Karen on Facebook says she's had a really serious reaction to it and I'm not prepared to do that, then you could be looking at dismissals. And certainly, Charlie, whatever his name is from Pimlico Plumbers, is on about not recruiting anybody who's not got a vaccine and blah, blah. And you could do that. You could do that if you want to. It would be some other substantial reason. It's not a misconduct issue. It's not capability or redundancy issue as such. It would be a SOSR, unless you were just having it as one of your criteria on a redundancy. Hope that helps.
Right, very topical one there. So this one, the next question we get a lot, and I'm sorry, I don't know the lady's name that's asking it. It's coming up as iPad 2, but I can see it as a lady asking. Where there are two employees with overlapping skills and only the additional skills of one employee and the additional skills of one employee are no longer needed, is it better to do a bumped redundancy or put both into a selection pool? So she's saying there's only enough work for one person, but basically, I think from what you're saying, it's difficult to pick between the two of them.
Yeah, I mean, and it is tricky. There are very rare situations, but situations do come up where people are identically scored and you still have to choose somebody to go. And, I have had situations where we've done a coin toss to determine who it is that's chosen. Ultimately, if that's the only option for distinguishing them, the tribunal will support you, but you're going to have gone through a pretty clear process first to assess people. Is it better to do a bumped dismissal or is it better to do a selection pool? Personally, I would go through and have both people at risk, both people consulted with, both people in a pool, score them and choose, because then you're seen to have treated them both fairly. You're probably going to have an employee who's more likely to accept the outcome, and you're probably going to find it easier to convince a tribunal that it was fair to choose this person and not that. With a bumped dismissal, if you remember, you just take one person, you choose that they are redundant, but then you put them into the role of somebody else and make that person redundant. And you can do that, and the tribunals will support that. But you need to make sure that you had chosen them fairly. And if your skills are overlapping in the way that you describe, you're going to find it difficult to show why you've chosen them.
Thanks. And from the same lady, and this is a quick one really, is when dismissing for redundancy with notice, is it acceptable to ask the employee to actually work their notice period? Yeah. And she's saying her convention is that it's usually pay in lieu of notice or garden leave, which does seem to be the convention these days, but it's nothing to stop that, is there, Sarah?
No, absolutely. Absolutely. It's your choice whether someone works their notice or is paid money in lieu of notice. So you can definitely do that. I suppose there's an argument for saying if someone has a long period of notice, so if you have, say, a director on 6 months notice or something of that sort, and you then get them to work their notice, there's an argument for saying, well, have you really got a reduction in the requirement for someone to do that work if you've actually got work for them to do for 6 more months? So the longer the period of notice, maybe you'll be more likely to pay in lieu, but there's nothing to stop you requiring them to work their notice.
Thanks. And Nicola's asking about the appeal question. So we were talking about appeals with redundancies and the fact that it can have impacts for other people in the pool. So she's saying an appeal normally comes through following the conclusion and people being given the decision. So how can it be put on hold if the income's been delivered to the individual? So I think she's sort of thinking about the logistics of it with the other people in the pool there.
Yeah. So 2 places at which you could have the appeal. So you could say, we'll go through the consultation as far as selection, and then we'll allow people to appeal against the selection. So we're still all in the pool, we're still all being consulted with, but the one who'd been selected has now appealed and we're re-looking at the scores. Or you could wait until the outcome, you could deliver the outcome, you're now redundant, and give them an option to appeal at that stage. But when you talk to the people who've been told that they are not going to be made redundant, you need to be making it clear to them, you haven't been chosen for redundancy, but I'm only giving you this as a provisional decision because there is an opportunity to appeal. And if the appeal turns the decision around, then we may need to come back to you and talk about redundancy again. So it's just a provisional decision that you're delivering to them. But this is why we say maybe don't have an appeal at all. Maybe just deliver the decision and be done with it. And then if the employee chooses to write in and say, I think it's unfair because X, Y, Z, you could hold an appeal if you wanted to. But it doesn't have that same unsettling impact on everybody else. Tash, I'm just conscious of time as well. We're about 25 past now. So I don't know how many more questions there are, but it might be worth just picking out one.
There are a few. I think we might just take one more and then see if there's some closing comments, and we can always come back to the other few later on. I'll just take Usha's. If a company provides settlement agreements at the same time as making redundancies, do the settlement agreement individuals count towards the amount of individuals being made redundant? So in terms of the numbers.
Yes. So if we're talking about collective consultation, yes, they do. It includes all the people who've gone on a settlement agreement. It includes people who've got less than 2 years service, so we didn't take them through a process at all. It includes any employees who have, who've been potentially, it's the potentially bit that's important, that if you didn't sign your settlement agreement, you'd have been on the redundancy list, so therefore you're included in it. I mean, if we very clearly have a settlement agreement that's been offered to somebody because they've been through a disciplinary process separately and it's to avoid the decision on that, or because they've got an ill health situation that was to, then we can exclude those. But if you're talking about people who volunteered for redundancy and signed a settlement agreement, they're in the numbers for collective consultation purposes. So,
lovely. So shall we, I think there are, as I say, a few more questions, but I think what we'll try and do is, if people are interested in following up on those, then, we'll certainly try to come back to you separately on those. But otherwise, we're going to hand back to Amy.
Thank you, Sarah and Tasha. That was really informative and really helpful, and I hope you've all found it really useful. I will take a quick screen of the remaining questions and fire them across to Natasha and Sarah after the call. But if anybody has anything additional that they'd like to ask, then feel free to email me. I'll follow up with an email after the call. So thank you. After this, I will put a post on LinkedIn. Please feel free to share and like to your networks. And thank you for attending. I hope you found it useful.